mandate of special procedures, because this is an opportunity to engage with different stakeholders, to go deeper into the situation in certain country, to see the legislation, but also to see the policies and practice how those laws and policies are implemented. And this is a very good opportunity for states to get recommendations, to upload to good practices, but also to raise concern and to give opportunity to states to change policies which are non-discriminatory. Which are discriminatory, not to change those who are non-discriminatory. And for example, here I put, for example, one statement. The first, when you see that, for example, the Reem Al-Salem, who is a special rapporteur on violence against women and girls, she announced that she will go to UK from 12th to 21st February last year. So you see how it is a very short information, but it's a good information, because then during her visit, although she has already arranged meetings, everyone who is in UK knows that she is in this country and can reach her with some additional information. And what you see on the right hand, or on the right part, is basically what she said at the end. So because every rapporteur has a short statement to media immediately when finishes the state visit, and then after several months she will finish the full report, which then will be submitted to bodies that I already explained to you. But what we see, for example, that she put in her, and she highlighted certain part of her findings, she said, the institutional violence perpetuated against mothers and children in family courts and the colossal failure of justice continue to be of grave concern, perpetuated through the invocation of parental alienation allegations and a move to maintain contact between the child and the perpetrator of violence, usually the father, at all costs. So this one is something that she really underlined, finding in her report that this is one very important barrier or problem that exists in UK at that time. When it comes to communications, I already told you that we have that special procedures have communications. There are three types of communications that special procedures can use. One is urgent appeal. What is urgent appeal? Urgent appeal is, for example, if a person is detained and there is a threat to his life and or to her health. If that person is supposed to be expelled from a country, and there is a risk that that person will be exposed to some violence, the threat to life, and so on. Allegation letter is the most common way of communication. Allegation letter is when there is a need for clarification in some cases which show that for example, there is a violation of human rights. For example, if the country does not treat correctly migrants and refugees or minorities and so on. And other letters are usually used for legislation. For example, when a state announced to adopt a law, or if they adopted a law which is discriminatory, which is problematic from the perspective of international standards, and then mandate holders, they want to warn the state either to withdraw from draft law or to change, to amend the law when the law has been adopted. What is important to communications is that, first of all, they are going with private channel. The first communication is submitted to the government, and the government is given usually 60 days to respond. After 60 days, that communication is published on the website of the Office for Human Rights, Commissioner for Human Rights Office, and it is made public to everyone. Communications, as I said, usually require from states to give some explanation on the situation, and usually states do not respond to those communications. If they respond, then that response is sometimes very weak or not really any information that was gained from the state. In any case, they can then repeat communications, and then even more mandate holders can join them in some future communications, and it's a very good way to pressure the government to do something and to finally respond. And you can see the list of these communications for each mandate holder and also the replies if there is a reply. I already said that they are published. And for example, here is the example of these communications. Here you see the date, you see who was submitted. Sometimes it can be, of course, anonymous if there is a need to be anonymous. Then it has its number. You see against which country it was issued, and you see on the left, in the second column, you see some keywords. And then you see on the right some more information on this communication. But if you go to the communication, which is on the left in the first column down, then you can press that, and the whole communication will appear with all information. What is extremely important for special procedures as the main tool of human rights diplomacy is that today we really have a great polarization between states on the role of all these mechanisms, including special procedures, that we have states which are claiming that colonialism is still very much present. This is why, for example, we have less representatives from Africa and from Asia, which basically today is really not the case, but we see backlashes, and this is what we said. Financial crisis is very, very present in the United Nations, and the problem is that states are not paying regularly their contributions, so it diminished the role of all these bodies that we just discussed, and it influences the efficiency of the human rights system. So at the same time, these are the challenges on human rights diplomacy. I also put in red one paradox, which is, while human rights are grounded in agreed norms that are not in theory open to renegotiation, diplomacy is pragmatic, fluid, and responsive to the demands of realpolitik. And this is really something that, so in a way, they're a very important tool of gain and achieve certain results in adopting conventions on international arena and doing something. But at the same time, diplomacy, as every single diplomacy, is very much shaped with real relationships among states, the power of certain states who can also either empower the system or diminish the system. And this is really very, very present. And here I put the words of the former Deputy High Commissioner for Human Rights. She said, "It is diplomacy in the service of human rights, or is it human rights as a tool of diplomacy in pursuit of foreign policy goals?" And she is, in a way, really right that we have also some states who are claiming to be very important actors in human rights, but then when we see what they're doing in their national level, we can ask this question. So what's really the goal of human rights diplomacy for certain actors, not really for NGOs and individuals, for really very strong, powerful, let's say, tool in this regard. So I'll stop here for this first part of the presentation, and I propose that we take 10 minutes break. Is it okay? Any question or comment to what we did?
No, but colleague Saiful wrote something in the chat.
Can you write it, please, because we don't see it?
I can read it to you. He said PowerPoint needs to be placed F5 screen view mode. I cannot read PowerPoint.
I will send you and it will be on your module, so you listen to me, because mostly what you'll have in your presentation, I'm really sorry, but we cannot do it better today. I don't know why, and there is no IT which can help us to provide you with better quality. But I apologize for that, and you will definitely have a presentation, so you will read everything at home.
There is
Okay.
also a Zoom option on my laptop. I can Zoom your presentation so I can see everything. So maybe other colleagues can try it also.
Okay, can you please just explain to colleagues how to use that option?
I just scrolled with my fingers on the mouse, like to zoom it in. So yeah, I just did that on the screen.
And it's functioning, yeah?
Yeah, and then I can see everything. I can zoom it however I want.
Okay, thank you so much, because it's a PDF, because for some reason the presentation was too big to be sent, I don't know why, and to be open. So in any way, thank you so much for this help, and we have 10 minutes break, so we meet at 12:45 to continue, okay?
Okay.
Thanks.
Okay, thank you. Thank you.
Okay, folks, I hope that you are here again. And just confirm that you can hear us.
We can hear you.
We can hear you.
We can hear.
Okay, thank you. So now we are coming to the second part of our presentation, which is called Gender Inclusive Justice and Composition of International Court Benches. And what is important for the historical overview is that it was very hard to follow this gender balance in international adjudication. Because first of all, prior to 90s, we didn't have most examples of women involved, and that was not an issue even in national arena as well. And what is extremely important is that for such a long time, international bodies that we have, and especially international courts and tribunals, they were male-dominated. So that was not a question for having, in a composition male on female, but if it was not the question, usually male were appointed. Why? Because we already see how the appointment goes. It also goes from the state. This is a part of diplomacy in international law, and the state usually recognize the famous male legal scholar or judge who was then appointed by international bodies. And the first problem and the reason for gender imparity. So why we speak about women being in these bodies? First of all, it is important that in majority of cases the whole procedure is not so transparent. There are no clear requirements. They're very general requirements. So you can put everything within that. If there is the requirement that someone is, for example, a famous. Not famous, but it's for example, standing scholar. How you will really measure who is a standing scholar? So you can say that someone published in certain, for example, in certain places, in Oxford Journal of International Law, that someone has a Cambridge monograph and so on and so forth. But then it's a very high let's say qualification, and it doesn't mean that someone who is publishing in some other places is not good enough for the position of being appointed as a judge. Then the problem was, of course, the discrimination, especially structural discrimination, which was a part of these procedures, because usually the procedures were held by males, by men, and also other men they were served in these bodies. So basically, it was a very important to that majority of them, they opposed female candidates, in a way saying, but okay, if they are best enough, they will be appointed. But that was really not the case, because due to those stereotypes and the called non-transparent procedure, it was very hard, less likely for example, female law professors to be appointed as judges. And it is also another issue that was the reason why we didn't have so many women in benches is family duties. In majority of countries, we still, even today, struggle with, for example, family responsibilities. So for many women, it meant that they either live, for example, in Strasbourg, because we have, for example, the European Court of Human Rights, who is established as a permanent court in Strasbourg, or it meant a lot of travels. And if you have a lot of travels and you have family responsibilities, you will also have some female candidates saying, I have small kids, I have other care responsibilities, so for me, it's really not likely that I will be able to travel that much. While for male candidates, there were always a woman who was taking care of children, and that was never basically an issue. When it comes to women in international judiciary, it is important to always pay attention to the rules for appointing judges. So if they are transparent and what are the qualifications for these jobs, then also to pay attention to the composition of women in permanent positions, but also you know that in international law, for majority of courts, we also have ad hoc judges. Ad hoc judges are those who are appointed, for example, to resolve one specific case, which involves certain state. This is also part of diplomacy in international judiciary. So it's not only that we look at the permanent composition of permanent courts, but ad hoc judges are also important. And the last thing, which is extremely important to get a whole picture of women in the judiciary, is how many of them are in higher positions. In other words, as presidents of the courts. In that regard, when it comes to ICJ and women judges, ICJ, or International Court of Justice, is the most effective and most important court on a universal level. This is a permanent body of the United Nations. And here we have, so far, as you can see, a huge discrepancy among male and among female judges. We had so far only 2 female presidents of the ICJ. The one who you see on this photo is Rosalind Higgins. She's maybe the famous judge at ICJ. And as you can see, she was the first woman ever elected at the ICJ, and she was also the first female president in 2006. But if we recall, when the court was established, basically the court was established in 46, but it also existed as a permanent court of justice since 1921 within the League of Nations. So when we take into account also that history when we didn't have women at all, and see this long history of existing court, that it really took a lot of time to come to the first appointed woman as a judge. And then we have the second female president and also the member which we had. When it comes to ad hoc judges, the situation is even worse because you see the total number of male judges and also only a few tiny number of female judges. This is the permanent composition, the current, composition of the court. Today we have 4 judges in the court, which is the highest number of judges in the court itself. Here you see the Okola, Judge Okola from Kenya. She was appointed 2-3 weeks ago, so she's just recently appointed. We also have a judge from Uganda. She's the vice president, and of course we have a president who is male. So, yeah, but again, among 15 judges, we have, as I said, 4 female judges, which is the higher composition. When it comes to current engagement of women as ad hoc judges, here I also gave you the list of cases where they were involved, and you have also their names. As you can see, they are also leading scholars in international law, and it means that for those judges to be appointed, they really had to have excellency in international law to be appointed. It's very high expectations from them. Did you have a chance to read the interview that I gave to you? Yeah. Do you have any?
Yeah.
Great. Do you have any comments on this interview? Because here we have basically some information on the number of judges so far, the composition, and why it is important to have female judges in the bench. And then we have 3 judges. So now we have the 4th one, but we had these 3 which were in a current composition of the court. And they had different views. They responded to different questions. Yeah. So is there anyone who would like to share some comments on what you read?
Maybe I can.
Please go ahead.
Yeah, for me, the stronger points, I have some notes that I made, but I don't remember who said it, which judge. But for me, the stronger points were when one judge said that it's really education is really important, and the school system. For the girls to have the same possibilities and the same conditions as boys, so that after they can go through the prestige law colleges and everything in order to get appointed to some big function like this one. And the second point which made an impression on me was that all 3 of them said it spoke about the struggle that they needed to do to prove themselves, and there was some funny anecdote about not having a female restroom in the court, which was like how is that even possible? But yeah, they didn't have women, so it was possible. So yeah, it was really interesting to read it, and also the 1995. I didn't know that. It's really I cannot imagine that for that long they weren't female.
Very good. Yeah, very good point. I think Dushanka also wanted to share something.
Well, no, it stuck with me also, not just the bathroom, but gender blindness here. She needed to remind them to feel her soul. So you need to remind somebody of your existence. So that's something that really struck with me, because it really reflects that time that you need to remind somebody that you also have needs as men, as your other colleagues, that you just that's something that is really just good point.
Good point. Any other thoughts?
Well, to me, it was interesting how the three judges have very different opinions about their role as a woman in the court. And I think two of them said that when the day comes when that's not going to be a topic, but it's going to be implied that there is a gender parity within the institutions, that we made it, basically. But then I think I had an impression that the third judge was really she thought that the competence is more important than the gender equality, and insisted that the competence is the reason why she got the job, and that it's important, not because she's a woman, etc. And then there we see that gender equality wasn't really a topic maybe for her, but is it that because we made it, or because we are ignorant of gender equality? And I don't think just she did said before the bathroom issue, the toilet issue, she said that she didn't have anything to overcome, but then said the problem with the toilet, and it made impression to me that it was just interesting to her. It's not problematic, but it's just interesting. Oh, they had to make a toilet for me. But that's just a fun fact, not a issue in international institutions that needs to be, talked about.
Very, very good. Very good point. You also seen that they have a totally different perspective. Here we have the three judges. And if you remember, they had a question that, did you ever feel as a woman judge to have to prove yourself more because of your gender to reach your position? And this is the Chinese judge. She said, definitely all the time, never take it for granted. When a woman takes a high position, people tend to doubt first before recognizing her role and competence. Such attitude consciously or subliminally exists. So that was her answer to this question. While Hillary, she is a very famous Australian scholar on gender equality. She said, when women are in a minority, in an environment like this, they stand out more, which sometimes generates more scrutiny of women on international courts and tribunals. Many people, when referring to female judges, will often specify woman judge. It's some kind of offense, like, oh, she's a woman judge, but male judges are not identified as such. We just assume that being a male judge is the norm. I hope we can get to a point where we are not called a woman judge, but just a judge. And then we have Rosalind Higgins, UK judge. She said, no, I have not had to overcome anything when I went to the ICJ. However, they did have to build me a separate ladies' restroom, and they had to be reminded that I needed a towel and soap, but that is the worst that has ever happened. So basically, that was the only very, let's say, basic thing that she mentioned. Of course, that it's something very important, but it shows that the court was not equipped to female judges at all. But her question was, no, I haven't had to overcome anything. So she was, in a way, she felt very well within her male colleagues, although at the time she was the only judge in the court. When it comes to the second question, how would you describe the progress of gender parity of the ICJ, or more broadly in the judiciary? The Chinese judge said, so far, not even a third of ICJ judge members are women. It is high time to recognize women's achievements. The United Nations has been playing a key role and is a driving force to promote gender parity. We have to educate people constantly about gender parity to counter the traditional bias regarding women professionals. It is not a question of numbers. It is a question of attitude. And this is extremely important, what she said. When people no longer pay attention to the number of women judges, that means it is no longer an issue. And currently, we still have a gap to fill. So she really explained in a very good way that the question of parity that we are struggling with is basically the issue that we have, and it shows itself that we have a problem. Then the Charleswood said that in the 28 years since Rosalind Higgins, who was first elected to the court, there have been 4 more women elected, including me. In the future, I would like to see a faster rate of change. The UN system is committed to 50-50 gender parity at all levels, and I would like to see the court achieve that. Of course, that is not up to the court itself, but to national groups who are responsible for nominating judges and the state supporting those nominations. In the longer term, I would like to see the day when the election of women judges to the court is not a matter of comment, when it is just taken for granted. So she finishes in a very similar way than to Xu. And this is extremely important that both of them recognize that we have a problem and that the parity was not achieved and that it has to be achieved. And then we have Higgins. She said, for women to be able to get to that position, they have to be extremely hardworking and very able. So in a way, how she explains, okay, you can get that position if you're really capable of doing that. I am for quality, and for the best person is a woman that is splendid. If the best person is from an ethnic minority, that is splendid, but I'm not looking for gender parity. The public does expect that a court handing down judgment that might affect them or their relatives or issue they care about should be handed down by people who don't look different from themselves. Finally, there must be diversity to reflect society, not on a parity basis or on a percentage basis, but to represent more generally the population by having the most capable people out there. So what we see from her point is that she is talking extremely about capacities, and it means that her position is also neutral. But of course, that it doesn't mean that female judges are not competent to be in the court. But in order to overcome these stereotypes and prejudices and everything that we've already mentioned as barriers for the election of women, it is extremely important to make an atmosphere in which it is possible. And what is obvious is that Rosalind Higgins is not addressing that issue in the same way as other 2 judges. What would be interesting and important here to understand is basically the personal life of these judges. What we can see is that, first of all, Rosalind Higgins was the only one who was appointed as judge, not to replace the vacancy of another person. And the vacancy is also replaced for this Kenyan judge, which was just appointed. So it's in a way the way of how they are coming to the court. What we see is that Rosalind Higgins, she graduated from prestigious faculties. She is married. She has 2 children, but she, with her title, she is married to a noble man. They are very rich, and in a way, she never had to experience caring duties in a way as other women. So it can, in a way, also explain that position of an individual who is a person who is in a very high society, not seeing realities which are shaped by others. When it comes to a Chinese judge, as what you can see, also she graduated from prestigious faculties, and she's also married. She has 1 daughter. While Australian judge, she also have prestigious diplomas, and she is married and she has 2 children. So basically, both of them are coming from some, of course, normal families where caring duties are much more present than in the case of Judge Higgins. But we really see that 3 of them have prestigious faculties. And it means that what Higgins is advocating for, and this is diversity within the court, does not exist. Because all of them, they, even male and female judges, they all graduated from Harvard, Columbia, from Oxford. And how those people can really understand the diversity in a society when they never had a chance to experience it at greater extent as some other judges. So this is an issue for discussion. When it comes to the International Tribunal of the Law of the Sea, this tribunal has 21 judges, and until last year we had 5. Now we have the 6th judge. The judge that you see up next to the letters is the latest appointed female judge. And this is not the president of the court, but this is the latest judge, and we have 6 judges among 21. So the parity is still not there. When it comes to ICC, or the International Court of Justice, that we will mention for some other classes, this is the court which deals with individual crimes, 4 core crimes such as genocide, war crimes, crimes against humanity, and the crime of aggression. When it comes to the composition, it is important to take into account several elements: the presidency, the chambers, office of the prosecutor, and registry, or the administrative body. And here, for the presidency, last year we had 3 male judges, male representatives. Now we have 2 female and 1 male, which is now the progress which has been achieved. And as you can see, presidency has a very important role in representing the ICC outside of the court, organizing the chambers, assigning cases, and performing a selection number of judicial functions. So they are very important, and it's good that we have 2 female judges, basically, who are serving in that composition. When it comes to judicial division, we have 18 judges in total. We also have different, let's say, a different organization within the judicial division, such as pre-trial division, trial division, and appeal division. Here, what you can see, last year, even we had less judges, but now we can see that majority of them I didn't count, but I think 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 judges apart among 18 judges are female judges, which is really the recent development that we have, a good example of this. However, when it comes to prosecutor's office, we have the prosecutor, who is a male, and then we have only 1 female lawyer prosecutor who is in the office. And also when it comes to registry, again, this is a male, although we also see that his role is very important. But we will hope that we'll have a swift change, that we will also have a female registry, because thus far we had only male registry within the court. When it comes to the European Court of Human Rights, which is really the most important regional court on human rights, especially for this region, what you can see is that we have a female judge who is the president of court, and we also have majority of vice presidents who are male, but we also have Gabriel and Ivana Jelic, who are vice section president or vice president. I'm sorry, Ivana Jelic became a vice president of the court, so I just I forgot that she was appointed. When it comes to former presidents of the court, apart from Judge Bosnia, here you see on this list all former presidents. And what you can see How many female presidents? Only one, and she was basically recently appointed, although the court was established in 1959. So it's a long, with first cases assigned in 61, but we see like 75 years of ruling within the court. When it comes to the current composition, also situation swiftly changes. Here are only female judges that we have. You know that we have 46 judges of the European Court of Human Rights, and among these 46 we have 16 female judges. So still they are under the parity. I mean, the parity has not been achieved, but in any case, this is a progress which has been done, and we have more and more female judges which are appointed to this court. When it comes to the Inter-American Court on human rights, we have, as you can see, 7 judges in total, 3 female and 4 male judges. So we can say, although the number is really very limited compared to the European Court of Human Rights, that we have a parity because we have we can't achieve a parity because we have seven numbers, but it is a good number of female judges. And also when it comes to the American Court for Human and People Rights, we have 11 judges, and among these 11 judges, we have 5 who are female judges, so almost parity achieved. When it comes to the gender parity and its mandate and the power that the courts see, we see exactly that ICJ is the most important, but at the same time, the ICJ is has not been achieving this gender parity yet, and it's a huge, still huge issue. Then we see in the middle European Court of Human Rights with a progress that has been made, and then we have other courts where basically we see that is parity has been achieved, or has almost been achieved. And finally, we should discuss what's the reason to include women judges, because someone can really discuss like why we really need to have women judges. And it is important that we understand that male and female judges, they also have different perspective and interpretation of the facts of the case and of the reasoning, because sometimes they can better understand the position of the party among them, because they can sense or feel under what conditions some situation happened. They can also use different models in that regard, being more sensitive towards, for example, violence against women, and they can understand the context and consequences more easily. At the same time, it is important that they, in their decision makings, that they enrich the discussion of different views. And for example, what we see, and we will discuss it for some of our next classes, that, for example, rape was not recognized as a crime for such a long time, but because male judges, they were not, for them, the rape was not in the focus of their work. So this is why it was not recognized. But then when it started to become recognized, now we have more and more female judges advocating for rape to be adequately addressed in criminal legislation. However, it does not mean that necessarily women judges will bring that perspective. And this is what we've seen from Rosalind Higgins and her approach. If you have a male-dominant professional life for such a long time, the women will start replicating their male judges. Sometimes even they don't want to be perceived by other colleagues as someone who came there under some measures, such as affirmative measures, for male judges, and that they are not equally qualified as female judges. So this is why not necessarily the age of number will bring better reasoning and more sensitivity towards gender issues. Finally, when it comes to one extremely important document which was adopted by CEDAW, this is a general recommendation number 40, which was adopted last year, and I also urge you to read this document. We have some, for this specific issue that we are discussing today, we have some main findings of the CEDAW. First of all, the 50-50 or parity is not only a starting point, but it's a universal norm. So the committee says you cannot derive because it's a universal norm. Then another issue is that the CEDAW said that equal and inclusive representation of women in decision-making system is a game-changing solution. And this is exactly what we are saying. So we're having more involvement of women in decision-making will bring change at some point. Then another point that we already discussed is that intersectionality and inclusion of women in all their diversity in decision-making system is important. So not all women, but not only women, but all women coming from different backgrounds, having different personal characteristics. Another feature is that state parties are required to ensure that women have equal opportunities to represent their governments at the international level. So their involvement at the international level in diplomacy, human rights diplomacy that we discussed is extremely important, but also to participate in the work of international organizations at universal and regional level is extremely important. And finally, the committee said, and parity in peace and security decision making. Because usually peace and security has a very strong gender perspective, and women are not participating in transitional justice, in negotiation process, in post-conflict situation. So we have to have a parity of women included in these processes. And finally, I will go with some final messages or key takeaways from today's class. Now, what we've seen when we speak about the judiciary is that we have a growing number of women judges, but still no gender parity. That there is an inversely proportional relation between gender parity in international bodies and power relevance. So where the power is still very much present, we will see less women involved still. Then appointing women to international benches is both the outcome of such work and a potential catalyst for ongoing transformation, but only if it is done in a way that we all understand the importance of including women and, of course, having qualified candidates for these positions. And that the presence of women remains much larger in some sector-specific adjudicatory bodies than in others, and that the overall percentage of women members of UN committees is prima facie much higher than that of the presence in courts and adjudicatory bodies, but that some committees have welcomed many more women than others, and we still have underrepresentation of women in some of them. So finally, when we look into the future, I again refer to the same general comment, which says that the long-term and structural absence of women globally from decision-making system constitutes a serious human rights violation and deprives the world of the potential of half of its population. So it's a very important finding, which of course was not invented by CEDAW, but CEDAW really pay so much attention to this. And finally, that the achievement of parity requires systemic action and a new approach to governance based on parity and inclusivity as a core principle and the leading force for transformative change. So the CEDAW is using a word, transformative change. We will not achieve transformative change if we do not achieve the parity, but through the intersectional lenses that I already discussed. With this, I will stop here and ask you if you have any question or comment to what we did today. Are you alive still?
We are alive, yes.
Okay, good. Okay, I'll now stop sharing this presentation that I can also see you. Great. So, is there anyone who would like to say something?
This was a very interesting lecture. Thank you.
Now you're welcome. You remember that you also had 2 papers to read. Is there anyone who had a chance to read them?
This one, but not the whole.
Anyone else? If no,
Yes, I read one about speaking about that a male judge is a totem and a female judge as taboo. I think that was the premise.
yes. So we had 2 texts, one on gender and the international judge towards a transformative equality approach. So see the same word that Asido is using, transformative approach, transformative equality. So this is something that we have to take into account very, very carefully. As many of you didn't have a chance to read it, I'll give you a first assignment for this course for the next Saturday. Please read these 2 articles carefully, and on half of the page, just give me your what for you. First of all, what was the core idea of these articles, and give me your opinion on this issue, taking also into account what we discussed today. Is it okay?
Yes. Should we do it on Moodle platform?
You can use the Moodle, and you can submit your papers there. Or if it's easier for you, you can send it also by email. So whatever is much easier for you. So the homework is for the next Saturday. That just give me for each paper half a page of the overview of what was the core idea and what you found very interesting, or maybe you disagree with, taking also into account what we discussed at class. Okay?
Okay.
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 Okay, thank you so much. And as I said, and just to repeat it at the end, please, whenever you're when you're able to come to the faculty, please come to the class, because the dynamic of the work is absolutely totally different when you're here. Okay.
Can I just say something? This weekend and the next weekend, I have some work seminars, which is why I'm not in Belgrade. But I will be able to join online, which is very useful for me to follow the materials. But I will submit the assignment maybe through email or Moodle, and I will be again online just next Saturday as well. Afterwards, I will be present.
Okay, just in a case, whenever you are really not in a position to come, use this opportunity to be online. But please, whenever you're able to come to the class. Okay. Have a nice weekend, and then see you next Saturday.
Thank you so much.
You're welcome.
Thank you. See you.
See you.
See you.
Ciao, ciao.
Bye.